Tyler Brands on behalf of the Office of Public Defender.
Just bring.
One and then do that, okay. All right. Good morning. How you doing? Will you be here this weekend? Just leaving me. Yeah, I get it. All right, sir, please tell me your name.
Rodney Hamilton.
21MM4713. You're here charged with trespass on property after warning. There is probable cause. Was there an offer?
Yes, Your Honor, the offer conveyed was an adjudication, credit time served, no return to the airport.
Just this was one client I didn't have a chance, if I could have a few seconds with Mr. Hamilton, Your Honor.
All right.
Your Honor, just for the court to know, his last conviction, that trespass was also from the airport, June 12th.
Okay. What was your offer?
An adjudication, credit time served, no return.
Your Honor, I did have a chance to speak with Mr. Hamilton. He would like to enter a plea on those, on the state terms today.
Please raise your right hand, sir.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, I do.
Thank you.
All right, you heard what, not your attorney, I'm not appointing him at this time, but as a friend of the court, what Mr. Branch just said to the court, is that what you want to do here today?
Yes.
You understand all the rights you're giving up by entering a plea of guilty or no contest?
Yes.
Do you have any questions for me about those rights?
No.
You understand if you're on probation, this plea will violate that.
Yes, ma'am.
And if you're not a U.S. citizen, this plea could deport you.
Yes, ma'am.
You also understand that I'm going to order that you can't go back to the airport.
Okay.
You just said okay, but I also see in your record, and the state just informed me that 2 weeks ago,
Yep.
you were trespassed from the airport. So you understand I'm going to order you can't go back.
Okay, but he wrote, I just want to explain something.
You can.
They wrote on top of my trespass, the number. I have to call somebody before I go back if I want to get on the flight. And they wanted you to see that. It's on a pink slip. He told me I wasn't personally banned. I have money on my hand right now. I was getting ready to buy a ticket. And I guess I didn't make the call first, and they thought I was trespassing. The money is it's here now.
Where are you going?
I'm going back to Baltimore, Washington.
Is that where you live?
That's where I live. I came here for a job with Disney, and it didn't work, ma'am, and I've been homeless, staying outside, and I finally contacted some people that I knew from Disney and ended up giving me some money to go back for a ticket. I
Okay.
guess the number he wrote on top of the trespass, he told me, it's not a problem, just call that number, and then it'll let them know that I'm in a terminal so I wouldn't get harassed by.
All right, well, I'm going to order something different today. What I'm going to order is that you can't go back to the airport unless you have a valid ticket in your hand. Do you understand
Okay,
that?
yes, ma'am, that works for me.
All right. So at this time, sir, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'm going to adjudicate you guilty, give you credit for the 2 days that you've been in custody. I'm ordering that you are not allowed to return to the Orlando International Airport without a valid ticket.
Yes, ma'am.
So you understand that?
Yeah, I should have one today, though.
Okay, but I just want to make sure, if you go back there and you don't have a ticket in your hand, they're going to arrest you again,
Okay,
all right?
okay.
I have to order that you pay court costs, but I'm going to give you a year to pay it based on what you just told me.
Yes, ma'am.
So it's about $300.
That's no problem.
When you get back to Baltimore, if you get a job and you can pay it faster, you can do that, and then you won't have it hanging over your head.
Yes, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing.
Thank you.
Yes, sir. Is this the interpreter? Is it?
I have it here.
Nothing lit up? No? My teleconference button did not light up. So it didn't, something happened. Hello?
Yes, good morning.
Oh, I hear it.
Can you hear me?
I can hear you. You're slightly soft. This is Judge Gibson. Who do I have on the line?
Good morning, Judge Gibson. This is Alex Moyes, the Creole interpreter.
All right, has the interpreter been sworn?
Not yet, Judge.
Please raise your right hand to be sworn.
Do you solemnly swear to translate from Creole to English, from English to Creole to the best of your ability?
I do.
Thank you.
Thank you.
All right, you're on the overhead speaker. All right, sir, please tell me your name.
Monsieur, dis-moi non, s'il vous plaît.
Wilson German.
Wilson German.
21 CF 7207.
C'est 21 CF 7207, car.
A warrant was issued for your arrest, charging you with aggravated child abuse.
Yo te voyé un mandat pour arrêter ou à cause de abus sous anti-moun.
A judge has already found probable cause.
C'est un juge qui déjà joué une bonne raison pour y arrêter ou là.
I'll appoint an attorney to represent you.
Ma ba ou un avocat qui pourrait présenter ou.
Your bond is $50,000.
Bon, et caution que vous mettez sur moi, c'est $50,000.
You are not allowed to have any contact with the victim in this case. Do you understand what no contact means?
Ou pas doué gagner aucun contact avec victime dans un cas ça. Répondre ça. Est-ce que vous comprenez qui ça veut dire par pas gagner aucun contact là?
No.
Non.
You may not speak to him. You may not call him on the phone. You may not send a message through friends and family. No contact at all.
Ou pas doué parler avec elle, ou pas doué relayer dans le téléphone, ou pas doué envoyer message à lui-même soit par l'intermédiaire de amis ou bien par l'intermédiaire de parents.
You may not possess a weapon, firearm, or ammunition.
Ou pas doué gagner aucune arme à feu, aucune munition.
You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings.
Il faut que vous allez habiter en l'autre côté. Moi, à permettre que vous retournez dans le cas là, une seule fois seulement avec un officier de police.
You must comply with any plans set in place by DCF.
Que ce soit plan que DCF établit sous loi, il faut qu'on suive toutes les directives et règles.
Do you understand?
Est-ce qu'on comprend ça?
Oui.
Yes.
I have nothing further.
Moi, pas aucun autre bagarre encore.
I believe that's all we have for the Creole interpreter this morning.
Thank you, Your Honor. You have a good day.
Thank you, you as well.
Bye-bye.
Okay, please tell me your name. What's your name?
Mavronis Harry.
I'm sorry?
Mavronis Harry.
21MM 4706. You're here charged with trespass on property after warning. There is probable cause. Does the state have an offer?
No, Your Honor.
I'll appoint an attorney to represent you. Your bond is $500, and you're not allowed to return to this scene for any reason. Do you understand?
Your Honor, the state's requesting a little bit of a higher bond. He just pled and trespassed at the same address with the same victim on July 6th. It has been approximately 2 days, and he went back to the exact same address with the same victim. The alleged victim, it is a private citizen. It is not a company.
Business?
Yes.
All right, I'll grant that. I'm going to raise your bond to $2,000. Not only can you not return here, you can't have any contact with the victim in this case. Do you understand what that means? You have to answer out loud.
Yes, Your Honor.
All right, thank you, good luck. No contact, not return. Please tell me your name.
Joanna Mata.
A capias was issued for your arrest in 21 CF 6571 for failing to appear for arraignment on a charge of petty theft with 2 prior convictions. The bond is $1,000, and I'll appoint the Public Defender's Office to represent you. And I don't think she's out on bond. It's a notice to appear.
Yes, Your Honor.
Your Honor, I was incarcerated when they,
I believe you. I can't change this because it was a KP assigned by another judge, but you may have a defense, specifically if you were incarcerated at the time. What you need to do is call the number on that piece of paper because your attorney can raise that defense in front of the trial judge, and that judge can quash the capias or change the bond amount based on your defenses. Good luck. Please tell me your name.
Quincy Elliott Moss.
20 CF 3265, a warrant was issued for your arrest for violating your probation as a violent felony offender of special concern by committing the traffic offense of driving while license suspended on June 11th, 2021 in Hillsborough County. There is no bond authorized on this warrant, and I will appoint an attorney to represent you. Good luck.
Your Honor, he's also a violent felony offender of special concern.
Yes, I said that. Thank you. Thank you.
Good morning, Your Honor. This is Theodoro Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Thank you. Please connect with the headset.
Interpreter is connected to the podium, Your Honor.
Sir, please tell me your name.
Jaime Chito Sotero.
Jaime Chico Sotero.
21 CF 398. You're here because a capias was issued for your arrest for failing to appear for a hearing on charges of petty theft of $100 or more and possession of an anti-shoplifting device countermeasure. There is no bond authorized on this capias, and I'll appoint an attorney to represent you. Good luck, sir. I believe that's all we have for the interpreter at this time. Thank you.
You're welcome, Your Honor.
I don't need to see it. Once we don't have to anymore, then I'll need them. Please tell me your name.
Name Terry Cooper.
Good morning, sir. You're here in 21 MM 4714, charged with retail petty theft. There is probable cause. Let me ask if the state had an offer.
No, Your Honor, it's enhanceable.
All right. I'm going to stay your bond at $250. I'm going to appoint an attorney to represent you. Sir, you can't go back to Walmart. No.
Yes, Your Honor.
Oh, it is Walmart. Yes, you can't go back to Walmart. You understand that?
Yes, ma'am.
All right, good luck, sir.
But what I do, they got a bond, I
You have a bond of $250.
don't get up today?
You can post that bond and you can be released today.
I don't get out.
I'm sorry?
I can't make no plea today?
No, you can't plead today because of your criminal history. The state doesn't have an offer for you. Please tell me your name.
Jeremy Rudolph, ma'am.
Got it. You have a violation of probation out of Hillsborough County in 13-11134. At this time, there's no bond. I'll appoint an attorney to represent you. And in 21 MM 4717, you're charged with resisting an officer without violence. There is probable cause in this case. Does the state have an offer?
Your Honor, since it was a violation of probation, state didn't offer one.
All right. I'll stay your bond at $500 and appoint the Public Defender's Office to represent you, sir. Good luck. Yes, sir. Please tell me your name.
Felipe Miguel Way.
21 MM 4715. You're here charged with possession of drug paraphernalia. There is probable cause. And in 21 MO 769, you're charged with disorderly conduct. There's probable cause for that as well. Was there an offer?
Yes, Your Honor, the offer on the paraphernalia was to no info it, and the offer on the disorderly was a withhold credit time served.
He has an extensive criminal history.
It's a city case, Your Honor, that's what I've been authorized to do on the city's behalf.
And I did have a chance to speak with Mr. Way, Your Honor, and he would like to enter a plea today on those terms.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
All right, you heard what Mr. Brandt just said. Is that what you want to do here today?
Yes, ma'am.
You understand all the rights you're giving up by entering a plea of guilty or no contest?
Yes, ma'am.
Do you have any questions for me about these rights?
No, ma'am.
You understand if you're on probation, this plea will violate that.
Yes, ma'am.
And if you're not a U.S. citizen, this plea could deport you.
Yes, ma'am.
At this time, how do you wish to plead to disorderly conduct?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs. I'll give you a year to pay them, and I believe the state has an announcement to make.
Yes, Your Honor, state announces no information as to 21 MM 4715, and I'm following it up with the clerk's office right now.
All right, good luck, sir. You have 30 days to appeal in writing.
Take care.
Thank you. Please tell me your name.
Alberto Rojas.
Twenty-one MM 2609. You're here on a capias for failing to appear for a pretrial conference on a charge of petty theft of $100 or more. The bond on that is $2,000, and I'll appoint an attorney to represent you. Good luck, sir.
May I say something, Your Honor?
Yes, but I just want to make you aware that everything you say is being recorded and can be used against you later. All right, Mr. Brands, you're going to have to talk to him outside. I don't know why that keeps happening. Sir, please tell me your name.
Keith Allen Cowell.
21 MO 770. You're here charged with possession of an open container of alcohol. There is probable cause. Was there an offer?
Yes, I've been authorized on the city's behalf to offer a withhold credit time served.
I did have a chance to speak with Mr. Cowell in the back, and we went over the terms of the offer as well as any citizenship and probationary issues with that offer, and I believe Mr. Cowell would like to enter a plea today.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Thank you.
All right, you heard what Mr. Branch just said. Is that what you'd like to do here today?
Yeah.
And you understand all the rights you're giving up if you enter a plea of guilty or no contest? I'm right here, sir. Sir, I'm the judge. Do you see me?
Oh, okay. I can't see and I can't hear, so.
You can't hear me?
Not very good. I mean, I can hear, but it's bits and pieces.
We're going to try a listening device and see if that helps you. All right, can you hear better now?
Yeah, I hear better now.
All right. You heard what Mr. Brands just said. Is that what you want to do here today?
Plead guilty? Or,
Right?
yeah.
And you understand that if you enter a plea of guilty or no contest, you're going to be waiving or giving up all the constitutional rights that he discussed with you.
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand that if you're on probation, this plea will violate that.
Huh?
If you're on probation anywhere, this plea could violate that.
Well, I'm not on probation, so
I understand, but I have to ask because I don't know if you are.
I'm sorry.
So you understand that?
Yeah.
And if you're not a U.S. citizen, this plea could deport you.
Right. I'm a U.S. citizen.
All right. Do you have any questions for me before I accept your plea?
No, ma'am.
Then how do you wish to plead to the charge of open container of an alcoholic beverage?
Guilty.
I'll accept your plea of guilty. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. Sir, I have to order that you pay court costs. I'm going to make that a lien. Good luck, sir. You have 30 days to appeal in writing.
How much is the court cost for?
It's about $300.
300? Do I get a little bit of time to pay it?
Well, I can give you a year or I can reduce it to a lien. Do you think you're going to pay it?
Yeah, I'm gonna pay it eventually.
Okay. Then I'll give you a year to pay it.
Yeah, 'cause I get, like, I make my social security $1,000 a month, so I can pay a little bit each month.
You can, and that way you have 12 months to pay it.
Okay.
All right, good luck, sir.
Thank you very much.
Yes, sir.
Thank you.
A what? Please tell me your name.
My name is Anthony Lazara.
Twenty-one MO 771. You're here charged with open container of an alcoholic beverage. There is probable cause. Was there an offer?
Yes, I've been authorized on the city's behalf to offer a withhold credit time served.
Your Honor, I did have a chance to speak with Mr. Lazara about that offer and the citizenship and probationary issues as well. He also wanted to let the court know about his income, Social Security, if he does wish to enter a plea today, but could you also consider court costs as a lien as you have in the past, Your Honor?
Hold on a minute. Okay, let me take this one. All of those. All right. Please raise your right hand, sir. Oh, sorry, that's you.
Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, to help you God?
Yes, ma'am.
Thank you.
All right, thank you. You heard what Mr. Brandt just said. Is that what you'd like to do here today?
Yes, ma'am.
You understand all the rights you're giving up if you enter a plea of guilty or no contest? Like your right to a jury trial, your right to remain silent, your right to testify on your own behalf, your right to call witnesses and presenting defenses you have at a jury trial when one is required. We're not going to do a jury trial here. You understand that?
Yes, ma'am.
And that's what you want to do?
Yes, ma'am.
Okay. Do you have any questions for me about those rights?
No, ma'am.
Has anyone threatened you or promised you anything to get you to enter this plea?
No, ma'am.
You understand if you're on probation, this plea could violate that.
I'm not on probation.
And you understand if you're not a U.S. citizen, this plea could deport you.
I'm sorry?
If you're not a U.S. citizen and you enter a plea to this crime, you could be subject to deportation. Do you understand?
Yes, ma'am.
All right, at this time, how do you wish to plead to the charge of open container of an alcoholic beverage?
No contest, ma'am.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in jail. I have to order that you pay court costs, and I'll reduce that to a lien. Good luck, sir. You have 30 days to appeal in writing. All right, sir, please tell me your name.
Matthew Hernandez.
21 MM 4718. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Ma'am, do you wish to testify?
Yes.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Brittany Davis.
I'm going to let the prosecutor ask you some questions.
Good morning. Can you please state your relationship to Mr. Hernandez?
Boyfriend.
Are you afraid of him?
No.
Do you want to have contact with him while this
Yes.
case is pending? I'm sorry?
Yes.
Has anything like this ever happened before?
No.
If anything like this ever happened again, would you feel comfortable calling 911?
Yes, but then nothing really happened.
Okay. That's all I have, Your Honor.
Any questions from the defense? All right. All right, sir, your bond is $500. You're not allowed to possess any weapons, firearms, or ammunition. Ma'am, I just want to clarify, you do want contact with him?
We have 4 kids together. Yes.
I'm going to allow you to have peaceful contact with the victim. Do you understand what peaceful means? No hostile contact. Don't even raise your voice. You understand? I'm going to order that you must comply with any plans set in place by DCF. Any other conditions the state would request?
No, Your Honor. You did no hostile,
I did.
no weapons.
I did. All right, good luck, sir. Thank you, ma'am. Good luck.
Did the rest of the city county ordinances bond?
No, we took him out of order.
We,
Oh, okay. That's why I was confused. Okay.
please tell me your name.
Aisha McGee.
21 MO 772, you're here charged with disorderly conduct. There is probable cause. Was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
She interested in that?
Oh, yes, Your Honor. We did have a chance to speak in the back. I talked about the terms as well as any citizenship and probationary issues as a result of entering a plea, and Ms. McGee would still like to enter a plea today.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
Just a moment. All right, you heard the state's offer. Is that what you want to do here today? You have to answer out loud.
Sorry, yes.
You understand all the rights you're giving up by entering a plea today?
Yes.
Do you have any questions for me about those rights?
No.
You understand if you're on probation, this plea could violate that?
Yes.
You understand if you're not a U.S. citizen, this plea could deport you?
Yes.
At this time, how do you wish to plead to the charge of disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in jail. I have to order that you pay court costs. It's about $300. How long will it take you to pay that?
I can pay it probably as soon as I get my property.
I'm going to give you 30 days. So you don't have to do it today. You'll have a whole month to do it. Is that okay?
Yes.
All right. I'll give her 30 days to pay. All right. Good luck. You have 30 days to appeal in writing.
Thank you.
Please tell me your name.
Timothy Marino.
21MO773, you're here charged with open container of an alcoholic beverage. There is probable cause. Is there an offer?
Yes, I've been authorized on the city's behalf to offer withhold credit time served.
Your Honor, I did have a chance to speak with Mr. Marino in the back, and I believe he wants to speak with our office and an attorney before taking a state offer.
All right, I'm going to stay your bond at $250, and I'll appoint an attorney to represent you.
As to the charge, I would consider, I would have you consider as there's no victim or property damage, if you would, and he has an address that he can get mail at, if you would consider ROR.
Your Honor, I believe the address on file is the Coalition.
Is what?
The Coalition.
So does that mean you object to an ROR?
Your Honor, he has 3 failures to appear, being as recent as 2019. And he does have a violent arrest history. So state would object.
All right, I'm going to release you on your own recognizance, but understand you can't possess or consume alcohol. You can't return to this scene. And if you don't come back for court when you're ordered to do so, you'll probably be held at no bond. You understand that?
Yes, ma'am.
All right, good luck. Please tell me your name.
Christopher Nyhart.
21MO774, you're here charged with disorderly conduct. There is probable cause. Does the state have an offer?
Yes, I've been authorized on the city's behalf to offer withhold credit time served.
I did have a chance to speak with Mr. Nahart about the offer, as well as the probationary and citizenship issues, and I believe Mr. Nahart would like to enter a plea today.
Please raise your right hand, sir.
Second, please.
Please solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God.
Yes, ma'am.
Thank you.
You heard what Mr. Brandt just said. Is that what you want to do here today? You understand all the rights you're giving up by entering a plea of guilty or no contest?
Yes, ma'am.
Do you have any questions for me about those rights? You understand that if you're on probation anywhere, this plea could violate that? And if you're not a U.S. citizen, this plea could deport you? Has anyone threatened you or promised you anything other than the state's offer to get you to enter this plea?
No.
At this time, how do you wish to plead to the charge of disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs. Sir, do you have a job?
No, ma'am.
Do you have a home?
No.
I'm going to reduce that to a lien. Good luck, sir. Please tell me your name.
Nicholas Cheatham Starks.
Donald Lickerback, Your Honor, representing Mr. Starks.
All right, thank you, Counselor, for putting your appearance on record. In 21 CF 8088, sir, you're here charged with trafficking in fentanyl, 14 grams or more, possession of cocaine with intent to sell or deliver. 2 counts of possession of a controlled substance with intent to sell, possession of fentanyl, possession of cocaine, possession of a controlled substance. Counselor, did you wish to be heard on anything in this case?
Yes, Your Honor. I point out that there's no evidence of any transaction or intent to sell. These are personal use amounts, they're small amounts.
Personal use amounts, I understand.
The most important thing is my client is employed full-time, works for Wyndham in sales of time sale. He has been working for Wyndham for 7 years. He has no criminal convictions. He's been in trouble with the law before, but misdemeanors. He's always appeared for court. I've represented him a number of times. I can vouch for that. He's never done any time in jail. Last night was the first night in his life that he spent in jail. So we have someone who is established that they show up for court. It's established that he has no criminal convictions.
Counselor, can I ask you about the battery in 2005? I show that that's a conviction, was it not?
I don't recall specifically.
It's the only conviction I show.
Says he did community service.
Okay, so it might have been, or it might have been a withhold, I'm not sure. Okay, thank you. I'm sorry, I didn't mean to interrupt you. I just wanted to ask about that
Didn't
because
interrupt, Judge.
I see that.
Your Honor, may I?
Let me just ask, is there anything else on that before I ask the state to respond?
Well, someone has written on the arrest affidavit some astronomical bonds which would stand in the way of release at all. I mean, it constitutes punishment without a trial. What we're looking for here is something to guarantee his appearance. We have no reason to believe that he won't appear. He's got counsel today, within 24 hours, to assist him. His family was in the funeral business. They're no longer in the funeral business, but they ran a funeral home in Orange County and Osceola County for a number of years. His mother was in charge of that business. She now lives in Atlanta. He's got a brother, but he's got family who care about him. And they will have to help him post a bond. A $10,000 bond would, I think, reflect the nature of the charges before the court, his record of appearances before the court, and assure that he'll be here.
All right, thank you. Let me ask the state for a response.
Your Honor, number one, I believe the bonds that are listed in the affidavit are appropriate given the level of the offenses that Mr. Cheatham Starks is facing. Second, as to his history, I do see that battery. I don't believe it was here in Orange County. But he has had prior drug arrests, one in 2018. In regards to counsel's argument that there was no evidence of intent to sell or deliver, the officer notes that he witnessed, based on his training experience, what he believes to be a hand-to-hand transaction. And then once stopped, the officer finds multiple different indicia of sale, including 2 small white measuring cups that presumptive tested positive for cocaine, a manila envelope that had a plastic white bag protruding from it, large amounts of currency, I believe a total of $2,131. There was a black scale, numerous jeweler's bags for packaging, 2 cell phones, SIM cards with his names on them, sandwich bags, and the white measuring cups, all of which are indicia of sale are sufficient to find PC for sale and delivery. And in regards to counsel's argument that these are all for personal sale, state would argue that these are large amounts of drugs as dictated by the Florida legislator, that these are not for personal sale, and that is why it's
Do you mean
indicated.
personal use?
Yes, Your Honor, sorry. And that's why they're, at least the fentanyl, it comes in as a trafficking amount because that is not a personal use amount as dictated by the Florida legislator. I believe 20.87 grams of fentanyl, 15.69 grams of crack cocaine, 8 alprazolam pills, 26 amphetamine pills, 44 more amphetamine pills, 4.37 grams of more cocaine. State would argue that these are not personal use amounts. And at least in regards to the fentanyl, the Florida legislator agrees, and that's why it's charged as a trafficking amount.
All right, I appreciate both counsel's arguments. I have to tell you, I do think that there's probable cause in the affidavit for the charges as arrested. In the affidavit, it does say that the weight of the fentanyl is over 14 grams. It's over 20 grams, actually. So I do think there's probable cause for each of the charges as listed. I think the law enforcement officer put the bond amounts per the bond schedule, but as counsel is aware, we don't follow the bond schedule. It can be used as a guideline, but it's not something to which we adhere.
It would be contrary to Norris versus State.
Right, we do not. Does this, I want to go back to your argument, I'm sorry, Ms. May. Does the state object to the court reducing the bonds?
Your Honor, state would ask that you at least stay count 1, and you could do subsidiaries for the other 6 counts. However, he is facing rather serious charges. Count 1 is an F1, facing 3 F2s, 2 F3s, and an M1. So given the slew of charges and given the severity of the charges, I would just ask that you stay count 1 and then find subsidiaries, if not stay them as they're currently set.
All right, here's what I'm going to do. Based on your arguments, counselor, I am going to reduce the bond, but not as significantly as you're requesting. At this time, sir, your bond on count 1 will be $150,000. Counts 2, 3, 4, 5, 6, and 7 will all be $150. I'll treat them all as subsidiaries. You can't possess or consume any controlled substance without a valid prescription. Do you understand that?
Yes, ma'am. Yes, ma'am.
Sorry, you have to answer out loud because we're making a record. You can't have contact with any known drug dealers. You can't return to the Floridian Express Hotel. Do you live there?
No, ma'am.
All right, so you can't go back there.
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
All right. Thank you for your arguments, counselor, and for appearing today. Oh, yes, 2?
It's a
Oh, that's right.
list
I'm sorry.
as well.
Hold on. 21 CT 4882. I forgot the driving while license suspended. There is also probable cause for that count. I'll treat that as a subsidiary as well. So your bond on that count will be $100. You can't drive without a valid Florida license. You understand that?
Yes, ma'am.
All right. Good luck. Thank you, counselor.
I'll write it down on paper and bring it back.
Your Honor, we had a reset this morning that got skipped.
It's in the afternoon.
Okay.
We didn't skip it.
Okay.
Please tell me your name. I can't hear you.
Jacinth Bergen.
21 CF 8042, a warrant was issued for your arrest for aggravated child abuse with a weapon, aggravated battery by strangulation, and child abuse. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Yes, Your Honor, as to count one, it is a life offense. State is asking that you hold a no bond pending an Arthur hearing.
No argument pending an Arthur hearing downtown, Your Honor.
All right, thank you. I will do that. At this time, you'll have no bond on count 1. Your bond on count 2 will be $50,000. Your bond on count 3 will be $25,000. Even while in custody, you can't have any contact with the victim or any witness in this case. Do you understand that?
Yes, ma'am. May I have a chance to speak?
You can say anything you want, but everything you say is being recorded and can be used against you. Do you understand?
Okay.
All right, let me finish, Mr. Brandt.
Yes,
You can't possess a weapon, firearm, or ammunition. You can't have any unsupervised contact with any minor child under the age of 18. You must comply with any plan set in place by DCF. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Do you understand?
Okay, can I say something to you, Judge?
Yes, but you understand everything you say is being recorded and can be used against you later, right?
Yes, ma'am.
Yes, go ahead.
Not with my information on it.
This guy.
Yes. All right, ma'am, what is it you want to say?
I believe, are you saying she has to have a separate residence from the children, or she?
I am.
My kids, ma'am, I'm a CNA, nurse assistant. I'm not trying to find no sympathy in my situation, nothing like that. My kids are not even staying with me. I made sure my kids had a proper residence to go to. I'm the sole provider of my kids. I pay my rent by myself, my lights by myself. I do everything for my kids on my own by myself. I even ensured that they went to their godmom's house to make sure they have somewhere safe to stay. I've never been in trouble before. All this is new to me.
Okay.
So do you understand everything that I've ordered?
Yes, ma'am.
All right, good luck. All right, 21 CF 8013, a warrant was issued for her arrest. Another judge has already found probable cause. I'll appoint, his arrest, sorry. I'll appoint an attorney to represent him. I find his behavior a willing waiver of his appearance today. No contact, no weapons, firearms, or ammunition, maintain separate residence. I'll allow one-time return with law enforcement to gather belongings. And the bond will be $5,000.
There's not an AS.
Please tell me your name.
Chaz De Young Horn III.
Attorney number.
A warrant was issued for your arrest in 21 CF 7830, charging you with aggravated stalking after a domestic injunction. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Your Honor, the allegations in the affidavit are pretty concerning, given the continued calling of the victim and the allegation that he was out of jail and promised to kill her and her children, made approximately 2 weeks ago. He is also out on bond for the same offenses. So state would just ask for a bond on this case and for you to revoke when it's out on bond. I believe he also has a violation of probation, so I'm assuming that on-view violation will be coming through shortly.
Yeah, I don't have that today, but I think you're correct. I do show he's on probation.
Yes, Your Honor.
I reviewed the affidavit. I do agree. The facts listed are fairly disturbing. And since, Mr. Horn, it doesn't appear that you are willing to comply with court orders, as you have repeatedly violated court orders already. In this case, the court is struggling to find any reasonable bond conditions with which you will comply. However, I will set your bond at $250,000. You understand that even while in custody, you may not have any contact with the victim. Do you understand?
Yes, ma'am, I do.
Tell me what no contact means to you.
No contact means no calling, no texting, no visiting, no anything in that era.
That's correct.
And I
You
have
can't
not
send a
done
message
that.
through friends or family. You can't contact her on social media. No contact at all. Do you understand that?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of her residence or place of employment. Do you understand?
Yes, ma'am.
At this time, I'm revoking your bonds in 21 CF 1636.
Now, can I say something?
You can say anything you want. Everything you say is being recorded and can be used against you later. Do you understand that? Go ahead.
This young lady that has this thing going on with me, anything that she sees me do on Facebook, anything that she even errs to say, it affected me right now. I have not done any of these things that she had, that as she say that she has me doing. And it's terrible because I just got out of jail on the 22nd. I just bonded out. And now that I'm home and I'm doing certain things, I'm working, I'm maintaining my situation, she is finding any and everything to interrogate my life. And I really want you to know that, because this bond and everything that goes on with the state and everything, this stuff is not true. And I keep going through this over and over and over again. And I'm not making these allegations to this young lady. This young lady just finding any particular reason to making you guys violate my probation and stuff like this. She's making my life terrible.
So according to the affidavit, law enforcement listened to 26 voicemails from you in the last 3 weeks.
Ma'am, that's not me. If anything, that is not me, ma'am.
Okay, listen, that's what's in the probable cause affidavit. I'm not going to argue with you today. Another judge has already found probable cause because a warrant was issued for your arrest. If you think you have some defenses to this case, you need to call the attorney and you need to have them raise it in front of the trial judge. But I'm not going to change any of this today. You understand? Good luck, sir. Please tell me your name.
My name is Guillermo Javier Lopez Cepero Mulero.
21 CF 8085. You're here charged with possession of Xanax and battery, domestic. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count one, $100 on count two. You can't possess or consume any controlled substance without a valid prescription, have contact with any known drug dealers. You can't have contact with the victim in this case. You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Ma'am.
All right, good luck, sir. Please tell me your name.
Alexander Pitts.
21 CF 8062, you're here charged with aggravated assault with a firearm, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $15,000. You can't have any contact with the victim. Do you understand what no contact means?
Ma'am.
You can't possess a weapon, firearm, or ammunition. I'll order you must maintain a separate residence and allow a one-time return with law enforcement to gather your belongings. I'll further order that you must comply with any plan set in place by DCF. Do you understand?
Ma'am.
All right, good luck, sir. Please tell me your name.
Hassan or Ashan?
A capias was issued for your arrest in 21 CF 7783.
Your Honor, and information has also been filed.
Oh, what does the information charge?
It is those 4 charges, Your Honor. It came in solely as an ag stalking after injunction, and we filed the ag stalk after injunction in the 3 violations.
All right, tell me what the 3 charges are.
It's the 4 that's on there, Your Honor. Oh,
I just want you to announce it for the record since it's your information.
aggravated stalking after an injunction in F3, violation of a repeat violence injunction of a prohibited place or date in M1, a violation of a repeat violence injunction by threat on M1, and a violation of a repeat violence injunction by contact on a certain date on M1.
Can the state advise if the victim in these cases, or in this case, is the same as the victim in the case for which he was last convicted in March of this year?
Yes, Your Honor. Oh, I believe that I have one from May of this year. It was a violation of a repeat violence injunction in M1. It was from May 11th of 2021. It was a withhold. It was the same victim, Ms. Gonzalez. He also has a 2020 violation of repeat violence injunction. He pled to that March of 2021. It is also the same victim. So we have one from May and one from March.
So twice this year, he's already been convicted of violating a repeat violence injunction against this exact same victim.
Yes, Your Honor.
Can you please print a copy of that information for me?
Yes, Your Honor.
In this case, not the old ones. Can we bring him back, Dexter? All right, we're going to bring him back at the end. If you can print that for me, Miss May.
Yes, Your Honor.
Yeah, I don't want the whole thing. It's too big. Okay.
Would you like the PC document as well?
Yes, please. That would be wonderful. Thank you. Please tell me your name.
Christopher Rodriguez?
A warrant was issued for your arrest in 21 CF 8086, charging you with aggravated assault with a deadly weapon, domestic violence, and criminal mischief. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond will be $15,000 on count 1, $100 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means? You're not allowed to possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you may not coordinate that with the victim. Do you understand? I'll order that you're not allowed to have any unsupervised contact with any minor child under the age of 18, and you must comply with any plans set in place by DCF. Good luck.
Would you like it now, Your Honor?
Sure.
May I approach?
Yes, please. Please tell me your name.
Thomas Towns.
Thank you. A warrant was issued for your arrest in 21 CF 7379, charging you with aggravated assault with a deadly weapon, domestic violence, and battery domestic violence. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $15,000 on count 1, $100 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
You're not allowed to possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you may not coordinate that with the victim. Do you understand?
Yes.
You also may not have contact with any witness in this case.
And Your Honor, in regards to his out on bond case, I did research it and it said there was a no information done on May 28th.
Is that correct? Did the state drop that out on bond case?
I am
Yes.
checking.
I'm asking the state.
Your Honor, we did file a no information on May 28th. However, we reopened it on June 8th. We reopened it and refiled.
So you did file an information
Yes, Your Honor.
with the same charges?
I'm reopening the information. It was tampering to hinder communication to a law enforcement officer, an F2 proceeding, so it's an F1. A false imprisonment with a weapon, an F2. Possession of a firearm by a convicted felon, F2. Ag assault with a deadly weapon, F3. Domestic battery by strangulation, F3. And a battery one prior, F3.
So it is all the same charges?
Yes, Your Honor.
So is he still out on bond on those charges?
I do not know if the bond, I don't see any motions for the bond to be discharged, and so I am not sure, Your Honor.
Yeah, it shows in the clerk screen they were discharged on June the 2nd.
All right, then I think if you want to file a motion for pretrial detention, you're going to have to do that, State.
Okay.
At this time, I'll take no action. Good luck, sir. Please tell me your name.
Whitney Fountain.
21MM4712, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. I'm going to place you on pretrial release with special conditions. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow one-time return with law enforcement to gather your belongings. You must comply with any plans set in place by DCF. Please tell me your name.
Kevin Holmes.
21MM413. You're here charged with assault, domestic violence, and battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500 on count 1, $500 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow one-time return with law enforcement to gather your belongings, but you may not coordinate that with the victim. Do you understand?
Ma'am,
Yes.
she wasn't from, she was from Tampa, but she was staying with me. So my residence is 729. She went back home to Tampa.
So I understand what you're telling me, but I can't order her to leave.
No, she's
So-
gone. That's what I'm saying.
I understand, but I don't know that, and I can't order her to leave. So I'm ordering that you maintain a separate residence.
Okay.
If you get there and she's there, you can't be there.
Okay.
You're the one who can be arrested for violating a condition of your release. You understand?
Yes, ma'am.
I believe you, but I don't know that. So if you get there and she's there, don't go in. Okay?
Yes, ma'am.
But if she's not there, you can stay there. I'm not saying you can't go back to that house. You understand?
Yes, ma'am.
All right, good luck.
You too. Thank you.
Yes, sir. Please tell me your name.
Lionel Gonzalez.
A capias was issued for your arrest in 2008 CT 4232 for failing to appear for pretrial on a charge of driving while license suspended with knowledge. The bond is $2,000, and I'll appoint an attorney to represent you. Good luck, sir. Please state your name.
William McClure.
A capias was issued for your arrest in 21 CT 518 for failing to appear for arraignment on a charge of no motor vehicle registration.
Yes.
The bond is $2,000.
Your Honor, there was an offer from the state of adjudication of guilt, credit time served, and I did have a chance to speak with Mr. McClure in the back about the state's offer as well as probationary and citizenship issues. As a result of entering that plea, I believe Mr. McClure would like to enter a plea today.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
You heard what Mr. Branch just said. Is that what you want to do here today?
Yes, ma'am.
and you had the opportunity to discuss with him all the rights you'll be giving up if you enter a plea of guilty or no contest?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am, I don't.
You understand if you're on probation, this plea could violate that.
Yes, ma'am.
And if you're not a U.S. citizen, you can be deported.
Yes, ma'am.
At this time, how do you wish to plead to the charge of no motor vehicle registration?
I'd like to plead no contest.
All right, I'll accept that. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for 2 days in jail. I have to order that you pay court costs. I'll give you I'll give you a year to pay them. You have 30 days to appeal in writing, sir.
Yes, ma'am.
Good luck. Please tell me your name.
John Berthard.
A capias was issued for your arrest in 20 CF 9291 for failing to appear for a hearing on a charge of attempted burglary of a conveyance. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck. Please tell me your name.
Christopher Betts.
A warrant was issued for your arrest in 21 CF 7112, charging you with grand theft of a motor vehicle, possession of alprazolam, and possession of methamphetamine. Your bond is $2,500 on count 1, $250 on counts 2 and 3. Another judge found probable cause. I'll appoint an attorney to represent you. You're not allowed to have contact with any victim or witness in the case. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Good luck. Is Carvalho next?
Yes.
All right.
Welcome to an Econo meeting. You are entering the meeting now.
This is Judge Gibson. Do I have anyone on the line?
Yes, Your Honor. How you doing, Judge?
Excellent, sir. How are you today?
Well, I'm sorry I couldn't make it. I had like 4 other virtual hearings in other counties, and I just didn't want to miss this one, so I was trying to see if I could appear virtually.
Absolutely. One good thing that came from the pandemic is now we can use technology to our advantage, right?
Yes, you're right, Your Honor.
All right, go ahead and put your appearance on record, Counselor.
This is Harold Thompson on behalf of Mr. Marcio Calvo.
All right, this is case number 21 CF 8038. Sir, you are Mr. Carvalho, right?
Yes.
All right, you're here because a warrant was issued for your arrest, charging you with robbery with a firearm. Another judge has already found probable cause. Does the state wish to be heard on bond?
Yes, Your Honor, given that the count is a punishable life offense, state is asking that you hold him no bond pending an Arthur hearing.
All right, Mr. Thompson, did you wish to be heard on anything?
Yes, Your Honor. I would like to be heard in this situation, Your Honor. It seems, I understand that another judge has found probable cause in this matter, but he has substantial ties to the community. He's pretty much born and raised here, even though his family is from Africa. He has a job. He has substantial ties. He would be present at all future court dates. This case is not one of those cases where it's like the state would be able to prove proof of guilt, evident or presumption. Great. I believe this is definitely a case of misidentification. Someone must have hacked into his Snapchat or something and committed this crime. My client has a solid alibi, and I would ask if you would consider modifying the no bond to a reasonable bond so we can go ahead and address this case in the trial division.
What says the state?
Your Honor, as to that argument, that's all things that can be argued downtown. Per the affidavit, I do not believe it is a mistaken identity. The victim did identify the defendant via a photo lineup. So state would still ask for no bond. And if counsel wants an Arthur hearing today, state would ask that you find it from the 4 corners of the affidavit.
So, Mr. Thompson, my understanding of the law as it sits currently is that your client is entitled to one Arthur hearing. The judge downtown could have a different interpretation of the law. I know there is a split in the DCAs. But if you ask the court to find proof evident presumption, great, and I do that, there is a chance that the judge downtown may not let you have a full Arthur hearing. Because obviously we don't have witnesses and you're not here today. I don't think you want to do a full Arthur hearing today. And I want to make sure that you and your client understand that. I'll spend a few moments, I'll review the affidavit, and I'll decide if I find proof evident presumption, great, but I don't want you to miss out on the opportunity for a full Arthur hearing if the judge downtown says, no, my interpretation of the law is you've already done it in the jail and you don't get another one. You understand?
Your Honor, we definitely don't want to waive our right to Arthur hearing in this case. I just believe that just based on the four corners of the affidavit, it's with a possible suspect. This is the information. I mean, you can see it for yourself, Your Honor. I'm confident that once we are provided a full bond hearing in this case, where we could present witnesses, that this case will eventually be dismissed. It has to. This is a mistaken identity case. There's no way around it. This is not my client. You don't just advance to robbing someone. You've never committed a crime before, other than a minor driving while license suspended offense. He has no reason to rob anyone. He's a school teacher. This is a case of mistaken identity. But I'll take that up with the trial division if the court is not inclined to consider setting a bond in this case.
I'm reviewing the affidavit. I was listening to your arguments, but I'm also reviewing the affidavit, and I understand and appreciate your argument as well as the state's. I do see that there's a photo lineup, but I understand your argument about technology.
Your Honor, as to that, the victim noted he is born in the month of May, making him a Taurus. He was born May 16, 1988. Told her that he was from Africa. From defense counsel's argument himself, his family is from Africa. The victim has said other things other than identifying him by the photo lineup. She's identified him from other means.
Counselor, I think you have some pretty compelling arguments. I'm just hesitant to consider that and set a bond today, and then, or find proof evident presumption, great, and then Judge Wooten decides that you're not entitled to that full Arthur hearing. I did ask the clerk which judge this is. It's Judge Wooten. Do you want me to make a finding, or do you want to file a motion in front of Judge Wooten right away and get this case in front of him?
Your Honor, in the abundance of caution, I would prefer to file a motion and have witnesses that we could present. We have alibi witnesses. We have people who's going to testify that my client was at a restaurant March 5th for his sister's birthday, leading up to March 6th in the morning of. And this is, Your Honor, somebody set my client up, or this lady just made a mistake for some reason. I'm not even sure why he was even listed in the lineup at all. But I don't want to risk losing an opportunity to have him set out on a bond by affording him a full-blown hearing in regards to this issue. And so
I think that's wise, Counselor. It sounds like you have some great arguments. I just would hate for your client to miss that opportunity. So at this time, I'm going to hold him at no bond with the condition you're not allowed to have any contact with the victim or possess a weapon, firearm, or ammunition. And then, Counsel, if you can get this in front of the judge right away, I'm sure you can get some hearing time quickly. That might be in your client's best interest.
I'll file it today, Your Honor.
All right. Thank you so much.
Thank you so much for your time. Thank you, guys.
Yes, sir. Have a nice weekend. Good luck, sir.
You too. Thank you, Judge.
Andrew Clark, he refused court.
21 CF 8072, there is probable cause. I find his refusal a willing waiver of his appearance today. His bond is $1,000. He can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Please tell me your name.
Lord Ramon Cora Santiago, ma'am.
A warrant was issued for your arrest in 21 CF 701, charging you with transient sexual offender failure to report within 30 days. A judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $15,000. At this time, I'm revoking your release on your own recognizance in 21 CF 2478 for this exact same charge. Sir, you have to maintain your sex offender reporting requirements.
Can I speak, Your Honor?
You can say anything you want, but everything you say is being recorded and can be used against you later. You understand that?
Yes, ma'am.
Is there anything you want to say, or you want to talk to your attorney? All right, good luck, sir.
Charles Dodd, refused.
20 CF 8665, I find his refusal a willing waiver of his appearance today. It's a capious with no bond, and I'll appoint an attorney. Tell me your name, please.
Walter Giles, ma'am.
A warrant was issued for your arrest in 21 CF 7955, charging you with sale or delivery of cocaine and delivery of cocaine within 1,000 feet of a park. A judge has already found probable cause in this case. Your bond is $2,500 on each count. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? I also show that you're out on bond and pretrial release in 19 CF 14822. I'm revoking that at this time. Good luck, sir.
So, can I ask you one question now?
Yes,
So I don't have a bond on that anymore?
right, not on the old charge. Your attorney's gonna have to file a motion in front of the trial judge to get you a new bond.
You said not to do that.
I'm sorry?
What did you just say?
Your attorney will have to file a motion in front of the trial judge to get you a new bond. All right, good luck, sir. Please tell me your name.
Nathan Griffin.
21 CF 8066. You're here charged with carrying a concealed firearm, possession of methamphetamine with a weapon, and grand theft of a motor vehicle. There is probable cause. I'll appoint an attorney to represent you. Your bond is $2,500 on count 1, $1,000 on count 2, and $1,000 on count 3. You're not allowed to have any contact with any victim, witness, or known drug dealer. You can't possess a weapon, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription. In 21 CT 4881, you're here charged with driving while license suspended. There is also probable cause for that charge, and I'll appoint an attorney to represent you.
Your Honor, could you make that bond amount subsidiary to the,
Yes, I'll do that. It'll be $100 on that bond. Good luck. Tell me your name.
Jaden Helm, JaydenHelm.
A warrant was issued for your arrest in 21 CF 6522, charging you with fleeing or attempting to elude law enforcement, unlawful assembly, and resisting without violence. A judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $15,000 on count 1, $100 on counts 2 and 3. You can't drive without a valid Florida license. Is there a place where the state would like me to order him not to return based on this charge?
I don't
No.
believe so, Your Honor. I believe
All right,
driving down the road and there's a DUI stop.
all right, thank you. Good luck. Please tell me your name.
Morning, Your Honor. Brandon Alexander Knox.
21 CF 71140. A warrant, I think that's an O. A warrant was issued for your arrest, charging you with grand theft of a motor vehicle. A judge has already found probable cause. Your bond is $2,500. You're not allowed to have contact with any victim or witness in this case. I'll appoint an attorney to represent you.
Your Honor, may I speak?
You can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand? Go ahead.
Thank you, Your Honor. I'm sorry to waste any of the court's time.
You're not wasting my time.
In this case, I was in another county and was served this warrant. When I was brought here, they gave me a copy of the warrant, but I have not been handed any copy of an arrest affidavit, no probable cause sheet, anything to tell me who the victim or victims in this case are. I would ask the court to order that those be given to me today so that I can see that. I mean, because if I bond out and I go see somebody that I have no idea who that is, I mean, those documents should be part of my arrest, and it was not part of my transfer to.
They're not. So what happens is, I appointed an attorney to represent you. Your attorney will file a demand for discovery, and the state of Florida has 15 days to respond to that demand, and that will have all the information in it. However,
You
I will
just
ask the
ordered that,
state,
right?
sir.
Okay, thank you. Go ahead. Sorry.
At this time, I will ask the state to please put the victim's name on the record.
One second, Your Honor.
Thank you.
Jessica Galvin?
So you can't have any contact with Jessica Galvin. Do you understand that?
Yes, Your Honor. Thank you very much.
Yes, sir. Good luck.
Sorry, Your Honor, it was buried in the
I
affidavit.
know, it's okay. Tell me your name. Sir? What's your name?
Ian Matrosic.
21 CF 8059. You're here charged with driving while license revoked as a habitual offender and grand theft of a motor vehicle. There is probable cause. I'll appoint an attorney to represent you. Your bond is $2,500 on count 1, $150 on count 2. You can't have any contact with the victim or the co-defendant, Rhett Taylor. Do you understand? You can't drive without a valid Florida driver's license. Do you understand? At this time, I'm revoking your bond in 20 CF 8097.
Would you consider setting just a different monetary amount as our notes indicate he's been working with our office as well as working on getting his license back?
Your Honor, state would object. It is a 2020 case. I understand he's trying to get his license, however, he picked up another Dwellis that likely HTO'd him, as well as a grand theft motor vehicle.
Also, it looks like his license is suspended for a DUI at some point, and there's a crack pipe found in this car that's stolen.
I looked up his driving report, Your Honor, I understand, but hold someone to no bond on a driving while license suspended. If you set a higher monetary bond, the last failure to appear was 7 years ago. And I would have you consider our notes that he's been cooperating with our office as well as working to get that license back. And he hasn't had a failure to appear in 7 years. I think a higher monetary bond will convince our client to show up for court when necessary.
So it's not holding him at no bond on a driving while license suspended. It's because while out on bond, your client committed a new law violation. A condition of being out on bond is you can't do that. So at this time, I don't find that argument compelling, Counselor. But I don't know if the case number is 20CT740 or 20CF8097.
I believe it was consolidated, 8097 was consolidated with 740.
All right, so it is the 20CT740.
That is my understanding. I can double check.
Yeah, and it's not even,
Yes,
it was
Your Honor.
revoked not just on a DUI, but for refusing to submit to
Do you?
a lawful test.
Yes, Your Honor.
I'm not. You'll have to file a motion. Good luck, sir.
For the clerk, it is the 20 CT 740.
Thank you.
You have a bunch. Ortiz Ramos. Please tell me your name.
William Robinson.
Thank you. 2019 CF 15863. A capias was issued for your arrest for failing to appear for a pretrial conference on charges of aggravated assault with a deadly weapon on a law enforcement officer, grand theft of a motor vehicle, fleeing or attempting to elude law enforcement with lights and sirens activated, driving while license suspended, and resisting without violence. There is no bond authorized, and I'll appoint an attorney to represent you. Good luck. Okay. Tell me your name.
Daniel Santamont.
A warrant was issued for your arrest in 21 CF 4201 for violating your pretrial release by not reporting to your scheduled office appointments several times.
No, ma'am.
There's no bond authorized on this warrant. I'll appoint an attorney to represent you. Good luck. I'm sorry? No. Tell me your name.
Darling Tiara.
20 CF 9495, a capias was issued for your arrest for failing to appear for a hearing on a charge of hiring a vehicle with intent to defraud. There is no bond authorized, and I'll appoint an attorney to represent you. Good luck.
Yes, ma'am.
21 CF 8065. I'm going to appoint your office, counselor.
We'll waive the appearance. I do have a PC issue with the.
All right, go ahead.
Okay. Sorry, Your Honor.
I think, can you go to that microphone? I'm sorry, just because I can hear you better. I'm sorry, counselor, I just want to make sure I hear you.
We did waive his appearance, by the way.
Right, yes.
You want to present the case? I don't know if you presented.
Go ahead.
Do you want to present the case?
It's already been called.
I called it.
Okay. As to the burglary of a dwelling, do the facts in the affidavit suggest he was one of the suspects in the dwelling? I know there were two in the garage, an open garage, but we don't know if he was one of the two in the open garage or the one just walking on the property.
Your Honor, in the second paragraph, it says, I was out with the correct suspect and he was one of the males he saw in the garage, per the victim's own testimony. A garage is in part of a dwelling, therefore there's PC for an unoccupied burglary of a dwelling.
That's all I needed, Your Honor.
It's what?
That's all I needed.
Okay. All right, I do find probable cause exists. I'll stay the bond at, it'll be 1,000 on count 1, 5,000 on count 2, and 100 on count 3. No contact with the victim or any witness in the case, not return, no weapons, firearms, or ammunition, no controlled substances without a valid prescription.
Your Honor, just to be clear, that was 1,000, 5,000, 100?
Yes.
Thank you.
Tell me your name.
Charles Washington.
21 CF 8087, you're here charged with petty theft with 2 prior offenses. I'm going to appoint an attorney to represent you. There is probable cause in this case. I'm going to stay your bond at $1,000. You're not allowed to return to the Dollar General at 57 East Michael Gladden Road. Do you understand?
Yes, ma'am.
Or have contact with any witness in the case. Good luck. Please tell me your name. 21 CF 77200. A warrant was issued for your arrest, charging you with written threats to kill, unlawful sexual activity with certain minors, extortion, and aggravated stalking. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Ma'am, do you wish to testify?
Yes, I'm his mother.
Hold on, I need you to raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
Yes.
Please state your name for the record.
Shakita Simone Thompson.
All right, I'm going to let the state ask you some questions, Ms. Thompson.
Yes, ma'am.
Ms. Thompson, you said you are Mr. Williams' mother?
Yes.
Okay. And do you have anything to tell the court today?
Yes. Christy, she's been coming to our house. She's been requesting money from him off of Cash App. You know, they've been talking. I don't believe he ever had sex with her because she used to come to our house. And her and her mother is good people. My son never got in trouble. I mean, he been in trouble, but he ain't been in trouble in 4 years. And if you was to give him a bond, he would go to Valdosta, Georgia with me today.
All right, thank you, ma'am. What says the state as to bond?
Your Honor, it's my understanding that he is entitled to bond on all 4 counts. I believe that written threats is an F2, count 2 is an F2, count 3 is an F2, and count 4 is an F3. So he is entitled to bond on all counts. So we just asked you to take into account the gravity of the offenses. He does have a pretty lengthy history, the last conviction being an aggravated stalking and a kidnapping.
And a false imprisonment?
Yes, Your Honor.
Yes, ma'am.
And I believe he has other history that leads the state to have some pause. He has a Florida arrest history of armed robbery with a firearm, attempted murder.
That's the same case that you're reading with Amaryllis, and he have 2 beautiful kids with her. That's why the charges was thrown out.
Your Honor, given that he has a pretty lengthy history of fairly serious offenses, and given the serious nature of these offenses, I just ask you to take that all into account when setting a bond, as he is otherwise entitled to it, and given we do not have the victim's testimony here today.
Yes, and he would go to Georgia with me today. I have my ID to prove where I stay at.
Yeah, I don't know that I want him to go to Georgia. He needs to be here to answer.
I would bring him to
charges.
every court date. I promise you that. I would bring him to every court date. Because I come from Georgia, because he plays semi-pro football. And he missed 7 games.
Does the defense wish to be heard on bond?
No, Your Honor, he is entitled to reasonable bond on these counts, and with the mother's testimony suggesting that he will appear for court, I believe the bond will be sufficient in having Mr. Williams appear in court.
At this time, your bond on count 1 will be $10,000. Your bond on count 2 will be $25,000. Your bond on count 3 will be $10,000, and count 4 will be $5,000. You can't have contact with any victim or witness in this case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of the victim's residence. You can't have any unsupervised contact with any minor child under the age of 18. I'll order you must comply with any plan set in place by DCF. Are there any other conditions the state would request?
Not at this time, Your Honor.
You can't possess or consume any controlled substance without a valid prescription, and you'll be subject to random drug screens. Good luck, sir. Thank you, ma'am, for coming. Good luck.
Thank you.
Tell me your name.
Jasmine Wilmore.
21 CF 7345. A warrant was issued for your arrest, charging you with burglary of a conveyance with a battery and battery. A judge has already found probable cause. I'll appoint an attorney to represent you. Yes, Ms. May?
Given that count 1 is a punishable by life offense, state is asking that you hold her no bond pending an Arthur hearing.
Mr. Brands?
As no objection pending an Arthur hearing with her attorney downtown.
I will do that at this time. You'll have no bond on count 1, $500 on count 2. You can't have any contact with any victim or witness in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of the victim's residence. Good luck. Tell me your name.
Ruby Diane Wolf.
21 CF 2342. A capias was issued for your arrest for failing to appear for arraignment on charges of possession of methamphetamine, possession of heroin, and possession of fentanyl. There's no bond, and I'll appoint an attorney to represent you. Good luck. Tell me your name.
Walter Wright.
21 CF 8064. You're here charged with possession of fentanyl, possession of cannabis less than 20 grams, possession of drug paraphernalia. I'm going to appoint an attorney to represent you.
Your Honor, may I inquire as to what the paraphernalia was in the arrest affidavit?
The clear baggie
Yes, ma'am.
containing the drugs, the baggies in and of themselves constitute paraphernalia.
They do.
Thank you, Your Honor.
There is probable cause. I'll set your bond at $1,000 on count 1, 100 on counts 2 and 3. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
Good luck. Tell me your name.
Glenn Clark.
A warrant was issued for your arrest for violating your community control in 19 CF 12087 by changing your residence without first procuring the consent of your probation officer or community control officer, by failing to report to community control as directed, and failing to remain confined at your approved residence as directed. There is no bond authorized, and I'll appoint an attorney to represent you. Good luck. Tell me your name. A warrant was issued for your arrest for violating your pretrial release by testing positive for drugs. There's no bond authorized on this warrant, and I'll appoint an attorney to represent you. I'm taking no action on the out on bond. Good luck, sir. Please tell me your name. 21 CF 7960. A warrant was issued for your arrest, charging you with aggravated assault with a firearm. A judge found probable cause already and set your bond at $5,000. You're not allowed to have contact with any victim or witness in this case or possess a weapon, firearm, or ammunition. Do you understand? I'll order that you must surrender the firearm within 24 hours of your release. A warrant was issued for your arrest for violating your probation as a violent felony offender of special concern by failing to report in person within 2 working days of release from incarceration, by failing to undergo a mental health evaluation as directed, and failing to undergo drug and alcohol evaluation as directed. There is no bond authorized on that warrant, and I'll appoint an attorney to represent you. At this time, I'm revoking his out on bond case. Good luck, sir. Tell me your name.
Brandon Klein.
A warrant was issued for your arrest in 15 CF 8929 for violating your probation by committing the criminal offense of grand theft. and no valid driver's license, attaching a tag on a sign, possession of drug paraphernalia, no motorcycle license, and no motorcycle registration. There's no bond authorized, and I'll appoint an attorney to represent you. In 15 CF 9762, a warrant was issued for your arrest for violating your probation, alleging all of the same offenses. I'll appoint an attorney to represent you. There's no bond on that as well. It'll be the same in 15 CF 9920. There's no bond on that. I'll appoint an attorney to represent you. The violations are all the same. In 15 CF 9922, the violations are all the same. No bond. I'll appoint an attorney. In 20 CT 469, a capias was issued for your arrest for failing to appear on a charge of no motorcycle license. The bond is $250. I'll appoint an attorney. 20 CT 470, a capias was issued for your arrest for failing to appear on a charge of no motor vehicle registration. The bond is $50, and I'll appoint an attorney. And then in 15 CF 9709, again, a violation of probation based on all the same new charges. There is no bond, and I'll appoint an attorney to represent you in that one as well. Good luck, sir. Tell me your name.
Rawan Parker.
A capias was issued for your arrest in 21 CF 4234, charging you with human trafficking for commercial sexual activity with a child under the age of 18. The bond is $100,000. You can't have any contact with any victim or witness in the case. You
Your
can't
Honor,
have,
That is a life offense. State is asking that you hold him no bond.
it is punishable by life?
I can double check, but I'm pretty sure, Your Honor. 1 second.
Okay.
3G.
If it's a punishable by life offense, you won't have a bond.
Why would I get a bond if they want to?
Your Honor,
Hold on, I can't hear you.
78706 sub 3 sub G reads, for commercial sexual activity in which a child under the age of 18 or in which any person who is mentally defective or mentally incapacitated as the terms are defined is involved, commits a life felony punishable under the statute.
All right, then I'll change my order. At this time, sir, you'll be held at no bond on that charge, but you're still not allowed to have any contact with any victim or witness in the case. Do you understand? I'm finding his refusal to remain in court a willing waiver of his appearance. I'll appoint an attorney to represent him in that. In 20 CF 8785, I'll appoint an attorney in that case as well, and he'll be held at no bond on that violation of probation. Tell me your name.
Jeremiah Gabriel Rodriguez.
19 CF 3073, a warrant was issued for your arrest for violating your probation by failing to report as directed, by failing to pay your cost of supervision, and by changing your residence without first procuring the permission of your probation officer. There is no bond, and I'll appoint an attorney to represent you. Good luck.
Yes, ma'am.
Please tell me your name.
Wendell Roundtree.
18 CF 6138, a warrant was issued for you for violating your community control by failing to comply with all instructions given to you and by failing to remain at your approved residence as directed. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck. Tell me your name. A warrant was issued for your arrest in 20 CF 8040 for violating your probation by committing the criminal offense of smuggling contraband narcotics into a detention facility. By committing the criminal offense of possession of drug paraphernalia possession of cocaine, and trespass in a structure or conveyance. There's no bond authorized, and I'll appoint an attorney to represent you.
First one got dropped.
I don't know if it may have, but you're going to have to talk to the trial judge about it. Good luck, sir. I signed these. Yeah, there's some I didn't sign, but those I did. Okay. Tell me your name.
Freddie Elias, Your Honor.
Looks like you have a warrant out of, I can't tell what county this is.
Broward.
It's in Broward? Hold on, it doesn't tell me that on the teletype. There it is. For violating your probation on charges of false imprisonment, aggravated battery with a deadly weapon, felony battery. There's no bond on this warrant. They will extradite you, so we'll notify them that you're here, and I'll appoint an attorney to represent you. Good luck.
Did Ms. Barthwerb bond? Barthwerb? Yeah. Thank you.
Please tell me your name.
Billy D. Williams?
You have a warrant out of Seminole County in 21725 MM for failing to appear for a pretrial conference on a charge of petty theft, $100 or more. Bond is $1,000, and we'll notify them that you're here so they can come and get you, but you have a bond.
Okay. Okay, that's cool.
I'm not going to take any action on the out on bond cases.
All right.
Good luck, sir. What's your name?
Hassan, Your Honor. Hassan Ashtan, Your Honor.
All right, this is recalling 21 CF 7783.
Your Honor, do you need a repeat of anything I said earlier?
Yeah, I think we need to revisit it. I was just reading the police report and the information that you provided.
Yes. So we did file an information. That was the PC document that we provided, and PC was found. The 4 charges are the 4 that are listed in the warrant, the act stalking after injunction, and then 3 charges of violation of repeat violence. He recently, in 21 MM 530, pled to violation of repeat violence injunction in M1. That was on May 11th of 2021. He also recently pled and 20 5039 to a violation of repeat violence injunction that he pled to that March 2nd.
Is he on probation for that?
Yes, he got a 12-month supervised probation sentence, so he should be on probation. I believe that ends February 24th of 2022.
So, Mr. Rushton, what I'm struggling with is the nature of these charges and the nature of what you just pled to. You are continually violating court orders. As a condition of bond, if I give you a bond, I have to be able to place you on conditions that are reasonable with which you'll comply, that balance your right to a bond with protecting the citizenry of Orange County as well as protecting the victim in this case. I'm going to ask your attorney, Counselor, I'm struggling to find any conditions that your client will comply with. Do you have any ideas?
Well, if the state plans on filing a pretrial detention motion, you can entertain that, but without a pretrial detention motion, you would have to set reasonable bond conditions. There are options for a curfew for the defendant. You can require the defendant to relinquish any and all weapons. You can require the defendant to meet with the PTR supervisor and keep a schedule of where they will be and when. This is done routinely for defendants on community control. There's case law that our office has found recently that requires the state to file a pretrial detention motion in writing. They can't do it, or a tennis. And the statute that we've used in the past, 907.0414C, subsection 4C, has to be read together with Rule of Criminal Procedure 3.132A. So before you can set no bond on an injunction like this, you would need the state to file one.
Your Honor.
Do you have a case for me, Counselor?
Yes, Your Honor.
You said there's case law?
I
Yes.
believe that is the case that Ms. George provided to the court earlier, which says that you have to make specific findings. It is, Your Honor, it's the same exact case, saying that you have to make specific findings whether or not to find him no bond. The way counsel argued it is, on my understanding and the holding of the case, is incorrect. It does not, state does not have to file a pretrial detention motion. You just have to find specific findings that the defendant is, there are no terms that you can place him on bond that you believe he will comply with, that this public safety is at issue, as well as the victim's safety. State would argue that the repeated violations of injunctions would go to that, as well as the two cases that state read earlier that he recently pled to are the same victim. Miss Stephanie Gonzalez. State just contends that there are no reasonable conditions of bond that you're able to place on Mr. Rushton to ensure his compliance, as the victim has done everything within her power to ensure her safety, including calling the cops when there are DV cases, as well as procuring and obtaining that injunction, which Mr. Rushton has proven that he will not comply with.
Counselor, I think she's right. If you read the case, the holding of the court is that at initial or first appearance, a judicial officer cannot make vague general references to information that's insufficient to hold someone, to detain someone pretrial. But if the court makes specific findings of fact that support a pretrial detention ruling, then that is lawful. There's nothing in this case that says it's not. However, here's what I'm going to do in this case. At this time, your bond will be $25,000 on count 1, $5,000 on counts 2, 3, and 4. You may not have any contact with the victim or any of her direct family members. Do you understand what no contact means?
Yes, Your Honor. And
Tell me what it means.
May I speak real quick?
You can say anything you want. Everything you say is being recorded and can be used against you. Tell me what no contact means.
Means no calling, not having a third-party member send a message, no social media, and none of that. And I haven't
Correct.
done that for over since last year, but recently she just filed another violation of injunction that was thrown out. I've been dealing with this same problem for 2 years, since 2019. I have a daughter with her that I don't even know that's mine. So you understand the frustration, yes, but I haven't violated the injunction. These are spiteful rumors. She moved into my household, Your Honor. And then after 6 months of pregnancy, her parents forced her to move back. And that's when all the paperwork and everything started.
Sir, the state filed an information charging you with these counts. And
These counts
the
have-
facts that are alleged are things like you're repeatedly going to her residence and leaving items. You're going to have to raise any defenses you have with the trial court. We're not going to have an evidentiary hearing on that today, but you can't have any contact with her.
You
You can't go to her residence. You can't be within 1,000 feet of her residence.
I haven't.
So you can't leave a bag at her door, you can't leave a
haven't, Your
bracelet on her
Honor.
car.
I haven't, Your Honor.
All right.
I haven't. If there's any
Listen, I need,
information that-
please stop talking.
I'm
I need you to listen to me.
I'm sorry.
I don't want to know if you haven't done it. I want to know that you understand you can't do it. Do you understand that?
Yes, ma'am. And
You can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of her home or place of employment. Do you understand that?
yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor. Just a question of pretrial. Do we know if a violation of probation is pending?
It is not.
It might be, though. Listen, sir, I think that you're on probation right now, so a violation of probation warrant might be issued. I just want to make sure that you know that. You need to call the number on that piece of paper and speak to your attorney right away. You understand?
Yes, ma'am.
Do you have any questions for me?
These are the only deals you have for me.
The only what?
Offers.
There are no offers. The court doesn't make any offers. I'm just telling you there's probable cause and what your bond conditions are.
And Your Honor, I'm telling you, for the past 2 years, past year, actually, this is all spiteful and pointed fingers, and I'm innocent.
I'm sorry, sir. There's nothing I can do about that.
Thank you, Your Honor. I appreciate you.
Good luck.
All right, good afternoon, sir. Can you tell me your name? Sir, you are here in case 2021 CF 8076 AO on charge of possession of methamphetamine. I did review your charging affidavit this afternoon and did find a probable cause for your arrest. I'm going to stay your bond in this matter one of $1,000. Condition of your bond is that you not possess or consume any drugs or alcohol without a valid prescription. Do not associate yourself with any known drug dealers or drug users. State, for these other open cases, I see he's in competency status.
Yes, Your Honor, I checked the 1179. It is in a competency status. Looks like the next hearing is December of 2021.
Okay. All right. I will not take any action on your out on bond cases, 2021 MM 1179 AO, 2020 MM 1597 AO, and 2021 MM 88AW AO. Sorry, 88AW. You have a great day, sir. Whenever you can post bond. $1,000. No drugs, no alcohol. I'm not sure, sir. I'm appointed public defender to represent you. Make sure you have an attorney. You have a great day, sir. If you're in my audience, could you please cover your face and nose? That would be great. Awesome. Thank you. Good morning, good afternoon, sir. Can you tell me your name?
Robert Hill, sir.
Mr. Hill, you are here in two matters. The first one, 2021 MM 4720 AO, on charge of possession of drug paraphernalia. You're also here in 2021 MO 775 AO, on charge of disorderly conduct. State, do you take any action as to your case?
Yes, Your Honor, state's going to file a no info, and the offer, I've been authorized on the city's behalf to offer withhold credit time served on the disorderly.
All right. As 2021 MM 4720 AO, I'm going to release you on your own recognizance as to that case. 2021 MO 775 AO, which is a disorderly conduct charge. The city of Orlando is offering you a withhold adjudication of guilt and court costs. Do you want to accept that offer from the city?
Yes.
All right. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down, sir. Sir, you are here in case 2021 MO 775 AO on a charge of disorderly conduct. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes. Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve your case today?
No contest.
Do you understand by entering a plea of no contest, you're going to give up your right to all listed on that plea form that's in front of you?
Yes, sir.
All right, you'll give up all your rights on the water went down the wrong way. You'll give up all your rights that listed on that plea form today.
Yes, sir. I understand. Yes.
And are you under the influence of any drugs, alcohol, medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
All right. I've had an opportunity to review your charging affidavit, so I did find a factual basis contained therein. I'm going to accept your plea of no contest. Find your plea is freely and voluntarily entered. I want to withhold adjudication of guilt. I'll give you credit for the 1 day that you spent in the Orange County Jail with 1 day credit time served. The court costs in this case are $223. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
You too. Thank you.
All right. All right.
May I approach?
Yes, ma'am.
Just gonna put it back.
Good afternoon, sir. Can you tell me your name?
Van Michael Brown.
Mr. Brown, you are here in case 2021 CF 7982AO on charge of written threats to kill or do bodily harm. I reset your case from yesterday because I didn't find probable cause for your arrest as to that particular charge. So the state of Florida is giving me a new charging affidavit. I'm going to take an opportunity to read that for a moment, and then we're going to adjust your case. You understand?
You know, I got 4 kids that are police officers.
Yep. Just give me a moment. Just give me a moment. We can get on.
I was letting people use my phone.
I know, sir. Let me read what's going on, and then we can adjust your case, okay? All right, we're going to take a quick recess while I do that. All right, let's go back on the record in case 2021 CF 7982AO. All right, So this particular statute, that having to do with 836.10, with my reading of the case law, is interpreted that it still has to be some kind of actual writing, not just verbally threatening somebody.
It says also an electronic communication.
Hey, Your Honor, these people
Oh, wait,
killed
wait,
my own mother.
hold on.
Mr. Brown, what's best?
My, like, the interpretation that I've taken also from the case law is that includes text messaging, not just paper and pen, not, it's, a phone call is still a phone call if you were yelling across the street or picking up the phone and calling Europe or anywhere else. It's still verbal. So it has to be some kind of documented situation.
People were using
They
my
added-
phone, Your Honor.
Wait, listen, wait a second. Please. If you let me finish with this,
Your
you
Honor,
may be
I have
happy with the
4
results.
kids who are
Stop.
police
If you give me a moment, let me finish talking to the state of Florida. You may end up happy with the results about to happen, so just relax. Give me a moment to figure out, make sure the state of Florida is, we're on the same understanding of what the law says about what charge they charge you for arresting you for, and whether I can hold you as to that charge. Because based on the information I received right now, and even with the supplemental affidavit from FHP, is that there was no composition, there was no writing to what we would consider under the statute to be a written threat. So, if you give me a moment, may get out here in a few minutes, like in about an hour or two. If you just give me a minute to let me finish, okay? Oh, not emergency number 2, I think. Yeah. So this may be a false 911 call, but
Yes, Your Honor. Mr. Brown has a significant history of false 911 calls.
yeah. So that may be the charge they were trying to arrest him for, but the charge they actually arrested him for actually requires some kind of posting online, written letter, email, text message.
I believe the breakdown in communication was the electronic communication, that there's no statutory definition.
Yep.
So they've been looking at 934.02.12 and 668.6027 Florida stats. And they've been looking to the manslaughter instruction to try to figure out what electronic communication means. But I understand Your Honor's position, and I don't have an argument.
All right, so, Mr. Brown, you may be charged later on for a different crime, but the crime for which you were arrested, the court does not find probable cause for your arrest, so I'm going to release you on your own recognizance as to that charge. I'm going to appoint a public defender to represent you, because probably there's going to be some charge against you later on, but have a great day, sir.
Okay.
Yep. Have a great day, sir. Yes, please. I reviewed. All right, good morning, ma'am. Good afternoon, ma'am. Can you tell me your name?
Quandra Harris.
Ms. Harris, you are here in case 2019 MM 989AW on a failure to appear warrant. The judge signed your warrant, set your bond amount of $1,000. I want to ask the state of Florida, do they have an offer to resolve your case today?
Yeah, sure. The offer given to the defense was a withhold, credit time served, court costs, no return to the Circle K, and restitution to the Circle K on the amounts of $4.99.
Your Honor, I spoke with Ms. Harris in the back, and she wants to work with our office or she wants to go over this case with our office. We would just have you set a bond, or set the bond as set.
Well, the bond is set at $1,000. Or orders you not return to the scene of the location, have no contact with any victims or witnesses. You have a great day, ma'am.
Thank you.
Yeah, I think it's, yeah, wasn't he already on the case? No. I'm appointed public defender to represent her. All right, it's case 2021 MO 776 AO, Mr. James. I'm going to reset him 24 hours from release from the hospital. This case 2021 MO 777 AO. Going to appoint the public defender to represent Mr. Lamar.
We'll waive the appearance, Your Honor.
All right, Mr. Lamar, I'm going to release him on mental health pretrial release in this case. Addition of his pretrial, if he does not qualify for mental health pretrial release, going to set his bond at an amount of $50. Addition of the bond, no return to the scene of the location. I'm sorry, and I'm not taking any action on his out on bond cases, 2020 MM 2701, 2020 MM 3302, 2021 MM 3709. Good afternoon, sir. Can you tell me your name?
Good morning, Your Honor. My name is Jordan Reed.
All right, is it Jordan Reed? All right, Mr. Reed, you are here in case 2021 CF 8077 AO on charge of aggravated assault and battery domestic violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. Good afternoon, sir. Can you tell me your name and spell your last name?
Masania Malcolm, Malcolm.
Straight ahead.
And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, Ms. Malcolm, can you tell me how you know Mr. Reed?
We have a child together.
Can't hear you.
We have a child together.
All right. And do you want to have contact with Mr. Reed while this case is pending?
Yes.
Has there been prior instances of domestic violence between you all in the past?
No.
Did drugs and alcohol play a role in this particular instance?
No.
If something like this were to happen again, would you feel comfortable contacting law enforcement?
No, Your Honor.
I can't hear you?
No.
All right. All right, Mr. Reed, in count one, I'm going to set your bond in amount of, a second. Oh, he's out on bond in Miami-Dade. All right.
In Miami, yes, Your Honor.
All right, we'll set your bond at count one, amount of $2,000, count one, $2,000, count two, $500. Condition of your bond is you have to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at this location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir.
Thank you, Your Honor.
Have a great day, ma'am. Good afternoon, sir. Can you tell me your name?
Ivan Redondo.
Sir, you're here in case 2021 MM 4723 AO on charge of battery domestic violence. I did review your charging affidavit in your case. I did find probable cause for your arrest. Ma'am, can you tell me your name and spell your last name?
Michelle Guzman, Guzman.
And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can put your hand down. Can you tell me how you know, is it Arnando?
Arredondo.
Arnando?
Arredondo.
Ardano. Mr. Ardano, there you go.
He's my husband for 12 years now.
All right. And do you want to have contact with your husband while this case is pending?
Yes.
Has there been prior instances of domestic violence between you all in the past?
No.
Did drugs and alcohol play a role in this particular instance?
No, sir.
All right. One second here. All right. Something like this were to happen in the future, do you feel comfortable contacting law enforcement?
If I feel comfortable.
Yes, ma'am. I can hear you.
If I feel comfortable?
Yes.
Yes.
Oh, there we go. So you got any questions for the witness?
No, Your Honor.
And Ms. And defense?
No questions, Your Honor.
All right. Sir, I'm going to set your bond in this matter, the amount of $500. Condition of your bond is that you to have, be subject to pretrial release supervision, you to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at this location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess or consume any drugs or alcohol without a valid prescription. You're subject to random drug and alcohol testing at your expense. I want to appoint the public defender to represent you in this matter. You have a great day, sir. You have a great day, ma'am. All right. Good afternoon, sir. Can you tell me your name? Mr. Bennett, you are here in case 2021 MM4719AO on charge of battery domestic violence. I did review your charging affidavit in your case. I did find probable cause for your arrest. I'm going to set your bond in this matter amount of $1,500. Condition of your bond is that you to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case. Do you have any questions about your no contact order, sir?
My kids are so suffering from that. I pay for where we stay at, where she stays at, and my kids stay at. That's gonna damage our whole economy. I can't afford it.
Okay.
I have a job, I missed a day already. That is, me and her get into an argument, my kids are having to suffer. You know that when a law enforcement calls, somebody has to go. I can't.
Okay.
I still have to, they still have to have.
All right, based on your prior criminal history and failure to appear, that's the appropriate bond to be set at this moment. You always take your case in front of Judge Wayne Shoemaker. He's the judge in Division 50, and file a bond motion with your attorney to, if my conditions were outside of your means or something that is appropriate. All right, have a great day, sir.
Oh, I'm sorry, I didn't.
You can take it up with your division judge, which is Judge Wayne Shoemaker. He's a judge in Division 50, which is domestic violence. You can file a bond motion. I'm not going to modify your bonds today. You have a great day. Good afternoon, sir. Can you tell me your name?
Darius Billups, sir. Your Honor.
Mr. Billups, you're here in case 2021 MM4724AO on charge of battery domestic violence. Ms. Davis, do you have I did find probable cause for your arrest. Do you have an updated sheet for him?
Your Honor, he has a fairly
All right, there you go.
lengthy DV battery history. Most were no pros or declined to prosecute.
Is they're all involving the same victim?
I have a 2021 misdemeanor bat DV, victim being Danielle Phillips. I have a 2020 non-arrest bat DV, victim being Miss Newbon. I have a 2019 misdemeanor bat DV. The victim was unwilling to prosecute. It was Miss Danielle Billups. I have a 2019 misdemeanor bat DV. Victim being Danielle Billups.
All right. All right, Mr. Billups, I want to set your bond in a manner, it's about $2,000. Condition your bond, you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Do you have any questions about your no contact order, sir?
Yes, sir. No. She said just contact the police to.
No contact. Well, contact the police if we need to go get your stuff.
Yes, sir.
But don't go over there without the police.
Right, we're currently going through a divorce and, well, supposedly moving out at the end of the month.
Okay.
So,
all right, well, hopefully you have an attorney, so you can continue on with your family law, like whatever's going on with your divorce, but you can't have any direct contact with her. So.
and so I can't get no lower bond than this, because I don't.
Not really. Based on like the chances that, well, chances are that, I want to see you again, based on the fact that we just saw you earlier for a similar offense that you were arrested for. That makes me uncomfortable in the release of reducing your bond. Now, you may want to think about, I know you're going through a divorce, and probably the reason you're going through a divorce is probably what's going on here, but you may want to think about getting some treatment, just for you, not for anybody else, to stop getting arrested for this kind of stuff. All right, have a great day. All right, good afternoon, sir. Can you tell me your name?
Jesus Mejia, sir.
Mr. Mejia, you're here in case 2021 MM4721AO on charge of battery domestic violence. I appointed public defender for Mr. Billups.
You did.
Okay, sorry, Mr. Mejia, let me make sure I did that. All right, Mr. Mejia, you're here for a charge of domestic violence in case 2021 MM4721AO. I reviewed your charging affidavit in this case, sir. I did find probable cause for your arrest.
That prior arrest was the same victim, Your Honor.
Going to set your bond in this case in the amount of $2,000. Condition of your bond is that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Now, it says on your affidavit for criminal indigent status application, an affidavit, that you make $2,200 a week.
Yes, sir.
All right. So you're not going to qualify for the services of the public defender based on that amount of money that you make. So you got to hire your own attorney to represent you in your case, or you can choose to represent yourself, which is in your constitutional right to do that. You have a great day, sir.
I have a question.
Yes, sir.
I own the house where I live at currently, that's on the report and everything. And currently, me and my wife are going through a divorce. She's
Okay.
no longer on the lease. So where would I be going at if that's my house, my name's on the lease?
As long as you maintain a separate residence from her. So if she's still living at the house?
But
You had to
my name's on the lease. She's not on the lease. If I tell her she got to go with the police, would the police escort her off the property of my house?
You gotta.
I'm the owner of the house.
I can't give you any legal advice. Only thing I can caution you against is having contact with her.
Okay.
And to make sure you stay 500 feet away from the residence or wherever she's living.
Okay. Thank you, sir.
Because I'm telling you now, if you violate my orders, I don't care if you're going through a divorce. I don't care what civil matters, you're upset that she's staying at the house. If you violate my orders, I'm gonna take it that we or you having a problem, and you're having a problem trusting you. So I'm gonna have to keep you here at the Orange County Jail if you do that.
Okay.
All right, have a great day. Good afternoon, sir. Can you tell me your name?
Terry Reed.
Mr. Reed, you are here in case 2021 MM4722AO on charge of battery domestic violence. I did review the charging affidavit in this case. It did find probable cause for your arrest. Good afternoon, ma'am. Can you tell me your name and spell your last name?
Natasha Mora, M as in Mary, O-R-A.
Could you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're gonna give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I can't hear you.
Yes.
All right. Can you tell me how you know Mr. Reed?
We have a kid together.
Okay. And do you want to have contact with Mr. Reed while this case is pending?
So the situation with that is,
Well,
I prefer not to,
Okay.
but he does have some of my personal items at another residence that he confirmed with the officers last night.
Okay.
And I went over there to retrieve them. They're at his residence that he shares with his other kid's mom.
Okay.
And she refused to hand over the items.
Okay.
So I don't know how I'm supposed to retrieve that or what.
I can't give you any relief as to that. You need to speak to possibly another attorney or somebody like that if you need to get to make sure that happens.
Mhm.
Only I can give, he's gonna order him to have no contact with you.
Mhm.
So he's gotta stay 500 feet away place from your place of residence, where you work, your vehicle, from you. He has to have no third-party contact, no contact whatsoever. So I can order him that. I don't have any jurisdiction over other people and things like that right now, okay? All right. Mr. Reed?
Yes, sir.
In your case, for the second question, did any drugs, alcohol play a role in this particular instance?
No.
And has there been prior instances of domestic violence between you all in the past?
Yes.
Okay. All right. And what was the latest one outside of this one here?
It was 2017.
All right. All right, Mr. Reed, I want to set your bond in this case amount of $750. It's going to come with pretrial release supervision. You're to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at the residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess or consume any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. All right. I want to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order?
No, but the police, they did retrieve my belongings out of her home, and they put them in my car. And then they took the car out of the driveway and parked it on the side. So would I be able just to go get in my car and drive off?
If it's 500 feet away from her house. If not, you're going to have to call law enforcement, and you're going to have to go there with them to get your car.
Okay. And I had also reported a firearm missing at the location, so that is something else I have to follow up on my own?
If you reported it stolen or missing?
Yes.
Yeah, you file a police report. As long as if it's not in your possession, that's fine. For some reason you find it underneath the glove box or in the car or in the engine or somewhere else in the trunk, you gotta turn that over to law enforcement.
No problem.
Okay?
Yes, sir.
All right, have a great day.
My sign. Do I still need it? Okay. Take that too?
All right. Yeah. Yep, sorry. All right, we ran all through traffic.
Innocent.
All right, sir. Okay. This is case 2021 CF 8079AO as well as 2021 MM 287AA. I'm going to appoint the public defender to represent Mr. Armstrong.
We'll waive the appearance, Your Honor.
I did find probable cause for Mr. Armstrong's arrest on all his charges: possession of amphetamines, threatening a public servant in 2 counts, and resisting officer without violence, and possession of drug paraphernalia. I'm going to release Mr. Armstrong in both cases on a mental health pretrial release. If he doesn't qualify for mental health pretrial release in both cases, as to his possession of, will state his bonds as set in his accounts. Condition of his bonds that he did not possess or assume any drugs or alcohol without a valid prescription, and he did not associate himself with any known drug dealers or drug users.
That was to the controlled substance and the,
As in both cases.
oh, so you're
Both
staying
cases
them,
staying
they
his
don't-
bonds as set, and then conditions are in both cases, no drugs, no alcohol, we're not associated with any drug dealers or drug users.
Understood, thank you.
All right. Good afternoon, sir. Can you tell me your name?
Darius Boston.
Mr. Boston, you are here in case 2021 CF 8074AO on a charge of possession of cannabis. Did review the charging affidavit in your case, did find probable cause for your arrest. I'm going to release you on pretrial release in this case. Condition your pretrial release that you may not possess any drugs or alcohol without a valid prescription. You may not associate yourself with any known drug dealers or drug users. You may also be drug tested, and it's a condition of your pretrial release in this case. I had a note here for child support, something, looks that way. Was you already seen on that?
I don't.
Okay, usually they tell me that, you gotta purge them out with some amount, but maybe not. All right.
That was the question I was asking. Do I get to go to the child support?
Yeah, well, after you're done with me, go appoint a public defender to represent you. You have a great day. All right. Good afternoon, ma'am. Can you tell me your name?
Stacy Lynn Guerrero.
Ms. Guerrero, you're here in case 2021 CF 5080 on a charge of fleeing attempt to elude law enforcement with license sirens activated and driving while license suspended as a habitual traffic offender. The judge signed your warrants case did find probable cause for your arrest. Gonna set your bond in this case in amount of $3,500 in count one and $2,500 in count two. Condition of your bond is you not operate a motor vehicle without a valid driver's license. I'm going to appoint the public defender to represent you in this case. You have a great day, ma'am.
Thank you.
This case 2021 CF 8093AO. I was going to appoint the public defender to represent Mr. Howard.
Your Honor, as to the, I have a PC challenge to one of the charges.
All right.
Smuggling contraband. I believe there's case law that suggests that the defendant must have acted knowingly, and in the arrest affidavit, I didn't see any facts that suggest that he knew about the contraband that fell out after he reported chest pains. He did hand over, I believe, some substance to the officer when he first asked. I have the case law if you would like to see it.
Your Honor, the facts indicate that the defendant was asked multiple times if he had drugs or contraband on his person. He handed some over, did not hand it over at all. I do not know the case law the defense has, however, I would
I'll
submit
look
that
at
that
it,
is
but
knowingly.
knowledge, intent, all that kind of good stuff usually
It's a
is a
jury
jury
question.
question.
Agreed.
There you go. So you're citing Valdez, $2, this is 189 Southern Third, 1050, 2016 case. Yep, and I would agree with that, what his case says, but as to,
Regarding a jury instruction.
what somebody has knowledge, intent, and all those kind of things like that is a question for the jury.
Would you
You
consider?
know, it usually, usually what's, if someone is in your exclusive control, I believe, is in the jury instruction, says that you're presumed to have knowledge of it, so,
Well, in the Valdez case, I believe, the court found that the defendant, I don't know, I think they assumed he forgot. It was in a locket of some sort.
Yeah.
It was in a pendant.
So it was a
My
roach.
argument is if there was evidence that he knew that he was bringing stuff in, then he could be charged. If no
Correct.
evidence shows that he knowingly brought in the contraband, why would he turn over some but not others?
That's a good question for a
I
jury.
can give you several reasons, but
I assume if he knew that he was gonna be found with it, he'd hand over all of it.
if somebody has a drug problem,
We wouldn't have.
which it seems that Mr. Howard may have, giving over some and not all of your drugs is a common practice. To gives the illusion that, that you're going to turn in the right path. I promise you, in every rehab facility in this country, that's what happens, happening. You know, people, you know, it's a substance abuse issue, it's not. But as far as where it's probable cause as to his 2 counts, and the court does find probable cause as to his 2 counts. Now, as to his, I'll set bond in count 1, amount of $1,000, count 2, $150. Condition of his bonds that he not possess or consume any drugs or alcohol without a valid prescription, and he not associate himself with any known drug dealers or drug users. I can go on the list of cases that I've been involved in when people have done exactly the same things, hidden drugs in places I didn't know you could hide drugs. Or would it be safe to hide drugs? All right. All righty. Good afternoon, sir. Can you tell me your name?
John Milburn.
Mr. Milbert, you are here in case 2020 CF 9112AO on a failure to appear warrant. The judge signing your warrant in this case set your bond at $0. Your bond's going to remain at $0 in this case. I believe you already have the public defender appointed to represent you in that matter. We'll get you in front of your division judge. You have a great day.
All right, thank you, sir.
Good afternoon, sir. Can you tell me your name?
Norman Moore.
Mr. Moore, you are here in case 2021 CF 80950 on charges of possession of methamphetamine with intent to sell and deliver, possession of cocaine, possession of drug paraphernalia in 2 counts. I reviewed your charging affidavit in your case, did find probable cause for your arrest. Going to state your bond in count 1, amount of $15,000, condition count 2, $150, count 3, $100, and count 4, I'm going to ROR you as to that count. Actually, these are set at 100, because what I'm about to do after that. Sorry, apologize. Count 4 is due 100. Condition of your bonds that you not possess any drugs, alcohol without a valid prescription. You may not associate yourself with any known drug dealers or drug users. You also have 48 hours to get to the Orange County Sheriff's Office once you are released from the Orange County Jail to report as a violent sexual predator or sexual offender. You are out on bond in case 2021 CF 401 AO. And in that case, the court's going to revoke that bond, find a probable cause that you committed a new law offense, and set a new bond at $0. We want to appoint the public defender to represent you and carry all your cases of which you're not already appointed. You have a great day, sir.
Do I got hold of it? I can bond out, or?
Nope, I revoked it. Have a great day, sir. All right. Hello, sir. Good afternoon. Can you tell me your name?
Jabarte Moten.
Mr. Morton, is it Mozart Moten, right?
Yes, sir.
All right, Mr. Moten, you are here in case 2021 CT 1219AW on charge of no valid driver's license. You're also here in case 2021 CF 809680 on charge of possession of cannabis and trafficking in oxycodone of 25 grams or more, but less than 100 grams or more. The review of charging affidavit did find probable cause for your arrest as to those 2 charges, as are 2 cases, and I'm going to set your bond in your.
Your Honor.
Yes, sir.
Can I be heard on the bond amount? I know trafficking in oxycodone is on the bond schedule as, I believe, $1 million. Mr. Moten, even with support from friends and family, wouldn't be able to afford even 10% of that. He's it says he's employed full-time, but I think he's almost like a laborer, day-to-day laborer, traveling around with circuses and then doing, I think, bounce castle sales on the side. So I don't know how much income there comes from that. He has had no failures to appear as well. I'm sure he'll be working with our office, as I'll instruct him to show up for any upcoming court dates on this matter. I would have you set a lower bond schedule than the one suggested or set a lower bond than the one set in the bond schedule. He also has children to provide for as well.
Okay.
Your Honor, respectfully, he's out on bond in Lake County on possession of cannabis with intent to sell and deliver, possession of MDMA, possession of cocaine, 2 counts of paraphernalia, and picked up these charges. I believe that was back in 2020. It's still open in Lake County. Given the trafficking in oxycodone, arguably this could have been charged as trafficking with a weapon, which would have been a life offense. Therefore, I think the bond that's currently listed is appropriate, given that otherwise he could have been charged with the weapon charge as well as trafficking with a weapon, which would have been a life offense.
With that in mind, Your Honor, if he can't afford the bond, it's tantamount to no bond at all.
That seems to be a popular argument, but it's not an actual legal one because it doesn't address anything in 903.0446. Doesn't it just? Yeah, that just addresses, that argument is popular, and I've heard it many times. And the problem with it is that for what it controls me or what the laws and the statutes say. So that never really addresses what 903.046 says. Now, there's some dicta in a lot of case law that seems to suggest that that's a consideration and seen in other writs of habeas corpus raised to the DCAs for various reasons. But the only thing the court has to consider is the only thing they write back is saying they have to consider the testimony evidence in front of them and make a determination of what bonds is according to the statutes and what the laws are. That's what their response always is from the DCA. But for some reason,
I understand.
that the argument is popular. I'm just letting you know.
The case law suggests Cameron v. State from the 3rd District suggests that that's where the phrase comes from.
Yeah, and that's what I said. It was a dicta part of a case that then became, but the actual holding of that case was the court needs to consider the financial means of the defendant, the danger to the public, all the things that are actually listed in 903.046.
I think there's also a larger constitutional argument of due process where if they can't afford, if the affordability of bail is at issue, it may go to not only the 14th Amendment, but the Constitution's due process clause.
Yeah, so the Constitution says that I can't hold somebody at no bond on a case that, there's either a life offense or a punishable life offense or capital offense, without finding proof of evidence presumption, great.
Yes, but the argument.
Literally, like a bond is a bond, even whether you can afford it or not.
But if he's held in no bond, it's like no bond at all, which may go to.
Well, I would say
process.
in the practical sense of it, but with the actual language of the law, the case and the statutes say, and what the Constitution says, that's not really where we are. Maybe someday, maybe our legislature and our, they'll change it and make it, more flexible for the judges up here to give us more tools.
You are able to set outside of the bond schedule, so
Oh, no, I am. I agree with you. And I probably would have, not barring that he was out on bond on this other drug dealing case.
Did he file an affidavit of insolvency by chance?
Yep, he did.
Just a moment.
Which, I don't know who he's supporting on $200 a week with 3 dependents. Which gives me
Yeah, sure.
more questions than answers.
Also, given the amounts of 117.5 grams of marijuana and
I'm talking about
33.1
109
grams of
pills.
drugs.
That's 109 pills, somewhere between $5 to $25 a pill. That's about the street value of that. Based on what he's saying he can make, he can't afford that in a month. All right. Mr. Morton, as to your no valid driver's license charge, 2021 CT 1219AW, you're going to set your bond amount of $250. Additionally, your bond that you not operate a motor vehicle without a valid driver's license. As 2021 CF 8096AO, I wanted to set your bond account 1 amount of $150. Count 2, want to stay your bond in an amount of $1 million. Condition of your bond that you not possess or consume any drugs, alcohol without a valid prescription. You may not associate yourself with any known drug dealers or drug users. You also, before you are able to bond out, even if your bond is modified, need to comply with Florida Statute 903.046, sub 2, sub F, and that the funds used to bond you out in this case did not come from any illicit source or the crime for which you are being charged right now. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir.
Nieves' behavior.
All right. This is 2020 CF 15093 AO. Mr. Nieves was supposed to be here on a charge of failure to appear in 1, 2, 3, 4 counts. And these are represented by the public defender's office.
We'll waive the appearance, Your Honor.
Want to state his bonds as set on his warrant amount of $0. The bonds, and going to get him on to his next court dates. All right. Okay. Mr. Walton. All right. Good afternoon, sir. Can you tell me your name?
Jaquay Kendall Walton.
Mr. Walton, you're here in case 2021 CF 8073 AO on charges of possession of cannabis and possession of drug paraphernalia. You're also here in case 2021 CT 48830 on a charge of no valid driver, driver license suspended. All right, as the court did review charging affidavits in these cases, did find probable cause for your arrest. As 2021 CF 8073 AO, we're going to stay your bond in an amount of $1,000 on count 1. Count 2, going to set your bond amount of $100. In 2021 CT 4883, going to set your bond amount of $250. Addition in both your cases that you not operate a motor vehicle without a valid driver's license, and you not possess or consume any drugs, alcohol without a valid prescription. You also may not associate yourself with any known drug dealers or drug users. You are out on bond in case 2021 CF 6497 AO, as well as case 2021 CT 3982 AO. Court find probable cause that you commit a new law offense while you're out on bond in those cases, going to revoke those bonds. Going to set new bonds at $0 in those cases. I'm going to appoint the public defender to represent you in both cases, in all your cases that you are not already appointed. Mr. Branch, you want to talk to him or you want to?
Just a moment, Your Honor.
Hello, Mr. Bain.
All right, there you go.
All right, I understand, man. I have two kids, man, and both of my baby moms are in jail. One of them is sentenced. Like,
Right.
Stay with me, man. I really care about these kids. Just can you please reinstate my bond so I can get home to my kids, man. I know you done heard this story a million times, but this is the God honest truth, man. I have my kids with me.
All right. I'm not saying that like the charges are the most serious charges I've seen like in the last 2 days. However, what I had to consider, we just had a discussion here in this courtroom before you came in, was in Florida Statute 903.046, which then also has included 903.0471. And I don't know what to do to stop you from doing what you're doing. I don't have any tools at my disposal at this point. Now, the legislature someday may give me more tools up here. I may be able to send you to rehab straight out of like where we're standing right now. I may be able to do all kinds of things that are, probably beneficial to a lot of people that appear in front of me at this very critical point where they are in front of me. However, I don't have any of those tools. So the only thing I can do to stop you from doing what you're doing is keep you here with me. So that's what I did. So have a great day, sir. Good afternoon, sir. Can you tell me your name?
Joshua Armstrong.
Mr. Armstrong, you are here in case 2014 CF 8-0-6472, AO, on a violation of probation. The judge signing your warrant in this case sets your bond in the amount of $0. Your bond is going to remain at $0 as to this case. You are what to consider a violent felony offender of special concern, sir. You will not be entitled to release on this case until your case goes to hearing. You have a great day, sir. Good afternoon, sir. Can you tell me your name? Mr. Pacheco, you were arrested in case 2021 CF 8080 AO on a charge of possession of a firearm by a convicted delinquent and possession of ammunition by a convicted delinquent. I did review the charging affidavit in your cases. I did find probable cause for your arrest as to those two matters. I'm going to set your bond in count one amount of, yes, sir.
I
Ms. Rance?
believe I spoke with Mr. Pacheco in the back. Can you give him a full explanation as to how you found probable cause for this case?
Yep. Okay, I was going to set
Yes,
bond, your argument as the PC, or you just?
No, I don't have an argument, but I believe Mr. Pacheco would like to hear your explanation as to how you found PC. My PC argument on Mr. Pacheco's behalf would be that it wasn't his car. The gun was found in the glove box. He didn't have actual possession of it.
Your Honor, state's response is constructive possession. He was in,
Yeah. You're exclusively, all right. Just thoughts about life, all right? You, as a convicted delinquent, have some issues going on. Your rights are restricted. So you got to live your life in a different way than most people that they didn't have the same past or same involvement with our juvenile justice center, like juvenile justice system, I apologize. Now, because of that reason, when you borrow somebody's car, you run a risk. Whatever's in that car, that's why you may not want to do it. Or if you borrow somebody's car, you have to be a little more cautious. Do a complete inspection. Go over the car. Make sure there's no roaches in the ashtray. No old weed underneath the seat or anywhere else. You may want to call somebody to get it vacuumed and detailed. I don't know. You got to take more precautions than a normal person because you run the risk of being arrested for this charge that you're facing right now. All right. So as a count one, I'm going to set your bond amount of $5,000. Count two, we're going to set your bond amount of $150. Condition that you may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Now, not saying that you're going to get convicted of this. I have no idea. No clue. But as far as this probable cause, which is a very low standard, it's one of the lowest standards, actually, it is the lowest standard of proof that we have. Besides scintilla evidence, I guess you may want to, if you want to throw that in as a standard, that one of the lowest standards of proof that we have is probable cause for your arrest, as well as there's probable cause that you violated your probation in case 2019 CF 1693 CO, and because of that, the court is going to hold you at no bond as to your violation of probation. I'm going to appoint the public defender to represent you in both cases. You have a great day, sir.
Your Honor, I believe, never mind.
Did I forget somebody?
No, Your Honor.
Somebody tell me.
No, you're